Thank you for having a look at this video. My name's Joan Olech. I am a director of a not-for-profit organization, a corporation actually, recently founded by Tony Kaluzny, myself, and Erica Fernie. The name of the corporation is Upper Canada Land Titles and Patent Research Initiative. The website for the corporation is patentresearch.ca. That's patentresearch.ca. The purpose of the corporation and the website is to inform and fund a constitutional challenge based on property rights, and the property rights came from letters patent granted by pre-Confederation sovereigns in what is now the province of Ontario. So it's fairly specific. The challenge at this point is going to be pre-Confederation patents, and specifically from Ontario because that's where the research has been done. So first I'm going to talk about the research. We have tens of thousands of pages of research, and literally tens of thousands of hours have gone into our research. Many of you will be very familiar with letters patent, and specifically your letters patent. As you know, letters patent are a contract. The specific ones that we're dealing with are pre-Confederation contracts, royal letters patent between the sovereign and the original grantee. And if you don't have your letters patent for your property, please, it's the first step in joining what could be very important in determining the value of your land and the rights you have over your land. So you can go to the OLA website and download the information to get your letters patent. You can come to my Facebook group, and my Facebook group is called Constitutional Challenge on Private Property Rights. Now, it's a public Facebook site. It's a group. You don't have to join the group to access it. You can just have a look at what we're posting. But I do have the application form for your letters patent on there. Now, once you get your true certified copy of your letters patent, that's step one. Pull out any deeds that you might have, or go to the registry office in your area and at least try to download a deed from the past, because it's more specific even than your letters patent in detailing your rights. Your letters patent says, for your sole and only use, heirs and assigns forever. No, it doesn't say for your sole and only use, actually. Letters patent says that the property was granted to the grantee, heirs and assigns forever. The deeds subsequent to the patent said sole and only use, heirs and assigns forever. That's really important because we know that that was the intention of the sovereign. It was carried on through deeds for a very long time. However, we no longer have access to deeds. What we use now are land transfers. Here's one, and this is from Service Ontario. You can go and pick up the land transfer, and there are two really critical things on here, besides, of course, your lot and concession and all that stuff. It says fee simple, and it says subject to the reservations in the Crown Grant. That's critical. Your current land transfer acknowledges that the reservations in the Crown Grant are valid. If the reservations are valid, because it's a contract, the entire contract is valid. Now, I'm not going to go all through everything that you probably already know, but I have a little bit of information that you might not know yet, and this is going to be critical to our court case. So, our letters patent, I have my letters patent here. So, my 200-acre parcel was granted in two parts. One of the grants went to Samuel Smith, the other went to Daniel Stafford, and one was patented in 1822, the other in 1827. Total of 200 acres. This was a service grant, military service, subsequent to the War of 1812. Now, so I only need the one to show you one of the most critical things that you have to look for to know if you're pre-Confederation. This says the province of Upper Canada. A grant that says the province of Upper Canada is a pre-Confederation grant. A grant that says the province of Canada is also a pre-Confederation grant, mostly in Victoria's time. A grant that says the province of Ontario is not a pre-Confederation grant. So, and the date should give you a clue. Now, my 1822 and 1827 grants, both issued by George IV to the original grantee. George IV was sovereign of the crown at that time. This is an imperial letters patent, an imperial grant, a royal grant, royal letters patent. Very important. The honor of the crown comes into play. This was directly from the king to the patentee. This is a contract no one can interfere with. Next thing I want to say is our grants are matters of record. They are not to be overlooked. They are not to be annulled. They are not to be ignored. This is a directive from the sovereign, and this is the will of the sovereign. The sovereign wanted to give some of his land to the original grantees, and in so doing, he couldn't give it to anyone else. It was gone. Once these patentees, once the land was patented, these land grants became for the sole and only use of the patentees. It was their land to do with as they wished, subject to the common law and subject to fee simple. Fee simple, what does it entail? It entails escheat, expropriation, police power, and taxation. So you got to pay your fair share of taxes. If you die without a will, it escheats back to the crown. Expropriation. Expropriation is really interesting because I happen to believe that it's not the Ontario Statute of Expropriation. It's the expropriation that existed at the time when your patents were granted. And at that time, expropriation was single purpose. It was for national defense. So, that's what fee simple means. The fact that the reservations are still detailed in every land transfer document means our grants are valid. They're for our sole and only use, heirs and assigns forever. There may be reservations in the grant as detailed on here, the Service Ontario Agreement. It troubled me for so many years. Why are they talking about a contract in terms of just reservations? That's a part of the contract. And I think we finally figured it out very recently. At Confederation, so in 1867, when the B&A Act was enacted, what the king, the queen at that time, so Victoria, had left in terms of the province of Ontario was just the reservations in the grants, plus the crown land that she retained. So she passed all of the crown land, plus the reservations in our land, to the province to administer. They're only administrators. They own nothing. There is only one crown. We talk about a provincial crown or a federal crown. There's only one crown. We have administrators, bookkeepers, and then we have the sovereign of the crown. So, everything was passed that the sovereign of the crown retained. And what they retained in terms of our private property were the reservations. So it might have been mines of gold and silver, it might have been beds of navigable waters, and it might have been white pine trees. Regardless of what the reservations were or are, they're retained within the crown, and that's why they are detailed on our Service Ontario agreement. So we have matters of record, and the reason our patented grants are matters of record is because once they were patented, they were put as the first entry into our land register. So the land registry system, first entry on every piece of property in what is now the province of Ontario, is the Crown giving land to someone. That makes it a matter of record. It's recorded in England and it's recorded in our land registry. And I'm going to say a little bit about the land registry because we use land titles now. I might get my dates a little bit wrong, but you'll understand where I'm going with this. In 1785, under King George III, the land registry was created to detail the root of title for each of our properties. After Confederation, in 1885, the land title system was concocted. And I believe, although I have no proof, that it was made so that the province of Ontario, in granting land, could have a separate place to put those post-Confederation grants. That may or may not be the case. What I do know is that without asking the owners, the title holders of the property, in approximately 1985, almost all of our titles were moved from the land registry to the land title system. Over the next 20 years, various dates of first conversion, but now we're in the land title system. And that transition, in my opinion, should never have happened, but that's for another day. So we have our land patents that say for our sole and only use, heirs and assigns forever. What rights do they give us? Well, because they're matters of record and because they're pre-Confederation, this is where it gets interesting. We don't believe that they're subject to provincial statute because we were never in the province. The province cannot legislate something which it never had ownership or control of. In reading the Constitution Act of 1867, Section 3, Executive Power, it says, property and civil rights in the province. Section 92 speaks to the exclusive powers of provincial legislatures, and again, subsection 13 says property and civil rights in the province. The most important word there is in. Because, okay, in is the most important word here because having been granted our land prior to Confederation, our land was never in the province. The sovereign could only give the province what it retained, which is the reservations. In the province, our land may be within the geographic bounds of what is the province of Ontario right now, but we were never in the province for the purpose of being legislated. Section 109 of the BNA Act of 1867 gives to each province the entire beneficial interest of the Crown in all lands within its boundaries, which at the time of the Union were vested in the Crown, subject to such rights as the Dominion can maintain under Sections 108 and 117. We weren't vested in the Crown at the time of the Union. Our private lands were vested in us, the patentees. So the reservations, again, to our land remain vested in the Crown, hence the provincial interest. Not so with the rights. They're ours, remain ours, will always be ours. So you've got your patent, you understand what fee simple is, you understand why we were never in the province, and now we have to get the courts to understand why the province and creatures of the province, being the regions and the municipalities, have absolutely no right to legislate on our private property. What we're saying is conservation, Nope, not unless you invite them on. We're saying Greenbelt absolutely cannot go on your property unless you want it on your property. Bylaw enforcement, absolutely not. There is no provision in our grants made for bylaw people to come on our property. We have been tricked, I believe, into thinking that the province has rights on our private property. And you know, if they hadn't pushed it so hard, maybe we'd still be okay with it. But we've gone from having all of the rights on our property. In fact, I'm going to go back just a little bit here. When our properties were originally granted, part of the process between grant and patent was that we had to clear 10 acres and build a dwelling. And once we had done that, we could get our properties patented, swear an oath and get our properties patented. Today, you can't build an outhouse on your property without securing permits from goodness knows how many agencies. The Conservation Authority, the Niagara Escarpment Commission, the bylaw people, you can't do anything. So what used to be given and granted for your sole and only use is now for their sole and only use. And they allow you to do what they allow you to do and nothing more. As a matter of fact, we've had cases recently where, for instance, flooding has happened on people's property. The waters get too close and take down your house. Guess what? You're not allowed to build there anymore. And no one else is ever going to be allowed to build there anymore. So what happened to all that equity you had? It's been wiped out. You own nothing. They've taken the rights to your property and transferred them to them. In any case, as I said before, we've spent thousands of hours, thousands and thousands of hours, thousands and thousands of pages. We have learned so much about our rights that were given and granted by the sovereigns and how they've eroded over the years to the point now where we have no rights at all. And in order to get back to an even playing field where private property is just that, private property, we feel that we need to go into the court and ask some very pointed questions. And I'm not going to tell you what the questions are, but what we intend to do, what we're going to try to do, is box the judge into a corner, and judge or judges, get them into a corner so that they have no option but to agree that our property rights have been stripped away from us unlawfully, and they must be reinstated immediately, and perhaps with compensation. I don't know. And it doesn't even matter about compensation, but you own your property. It's private property. It's yours. We want our rights back. We don't want green lands on it. We don't want conservation on it. We don't want anybody telling us what to do with our private property. And in order to get that done, we have to mount a constitutional challenge. In order to mount a constitutional challenge, we need a lot of money. And the only way to get that money is for everyone to contribute, to donate. So please, go to www.patentresearch.ca, and there you can send a check to Erica. The information is there. You can go to a GoFundMe page. The information is there. And if you're not able to contribute, that's okay. But those who are, because think about it this way. We have had, if you have a problem on your property today and you have to go and see a lawyer, no lawyer is going to give you, they may give you an hour of free time. But in order to get anything done, it's not going to happen in 1, 2, or 3 hours. And the cost of 3 hours with a lawyer has to be $500. If we get a few hundred people with $500, we're ready to go to court. If we get a few thousand people with $500, we're done. We don't even have to beg anymore. We can get into court, we can answer the questions, and we can use the precedent that we set in court to move forward and eliminate all these restrictions, this nonsense that the province and others have put on our property unlawfully. That's it. If we happen to win, and if you happen to contribute 2-hour win in terms of finance. And if the court awards us costs, all the money that's awarded will be returned to the contributors, and the reason, in a portion at least. So we'll apportion it back. We're never going to get everything we've spent on this, but whatever portion of the proceeds, or how can I say this? If the court awards us costs and we get some percentage of the money back that we've spent on this action, then we can turn around and send you your share of that award back. It's something. It's not a lot. We have no intention of making money on this, but we can't fund this on our own. We need your help. We really, really need your help. So patentresearch.ca is the name of the website. Constitutional Challenge on Private Property Rights is the Facebook group. Upper Canada Land Titles and Patent Research Initiative is the name of the not-for-profit corporation that we're operating under. Tony Kaluzny, Joan Olech, Erica Fernie are the 3 people that we'd like you to get in touch with if you have questions, and it's all there on patentresearch.ca. Our phone numbers, our emails, everything that you need. Again, thank you for listening, watching, and please contribute.